What happens when a duchess defies centuries of royal law and Parliament fights back with the full force of the crown? In an unprecedented move, the British Parliament has just passed a searing bill targeting Meghan Markle after she publicly declared her children Prince Archie and Princess Lilibet without legal approval. Now, with a 14-day deadline looming, Meghan faces the threat of a UK court summons for royal impersonation. This isn't just a family feud, it's a constitutional crisis with global implications. Did Meghan break the law? Is this political revenge or a defense of royal order? And what happens if she refuses to comply? Stay with us, because the next few minutes will uncover the chilling truth behind the monarchy's digital war. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. It was just after noon in London, the streets around Westminster thick with tension, as if the air itself anticipated something historic. Tourists lingered outside the Houses of Parliament, unaware that within the Gothic halls, a political firestorm was about to erupt, not over inflation, war, or immigration, but over a royal title. Not just any royal title, but the ones bestowed, or, as Parliament now argued, illegally applied to two children thousands of miles away, across the Atlantic Ocean. Their names, Archie Harrison Mountbatten Windsor and Lilibet Diana. Their alleged offense? Being publicly identified as Prince and Princess by their mother, Meghan Markle, the Duchess of Sussex, without constitutional or sovereign approval. The moment felt surreal. The very notion that a legislative body in one of the world's oldest democracies would interrupt affairs of state to confront a royal in exile over children's titles seemed like something out of a parody, yet it was deadly serious. By the time the bill was introduced, it had the backing of over 300 members of Parliament. It carried a name that was as dry and procedural as possible, the Royal Title Clarification and Protection Act, but its impact was anything but. It was triggered by what many MPs called unauthorized claims to nobility. Others used more incendiary language, fraudulent branding, royal impersonation, even title trafficking. Whatever the phrasing, the accusation was direct. Meghan Markle, no longer an active working royal, had unilaterally declared her children royal heirs with full titles, a move Parliament considered not only presumptuous but potentially criminal. Within hours, the motion was approved. Meghan was officially served a warning through diplomatic channels: remove all use of unauthorized royal titles from digital platforms, press materials, and legal documents concerning Archie and Lilibet within 14 days. Or face a UK court summons under the charge of title misrepresentation and impersonation of royal status. The headlines the next morning scorched across both sides of the Atlantic. Royal war reignites. Meghan faces court summons over kids' titles, declared one London paper. British Parliament threatens Meghan Markle with legal action, screamed a Washington outlet. Twitter exploded. CNN debated the legality. Fox News accused Meghan of political theater. In Buckingham Palace, the silence was telling. Not a single senior royal issued a public defense or a condemnation. But to understand how it came to this, to Parliament itself condemning a duchess turned rebel royal, you must rewind the clock nearly 5 years. Back then, Meghan Markle was the crown jewel of royal modernity, an American actress, biracial, outspoken, and married to one of the most beloved royals, Prince Harry. Their union was, at first, sold as a turning point for the monarchy, a bridge to the 21st century. A real-life fairy tale. But fairy tales rarely survive real-world politics. What began as a few clashes with British tabloids over wardrobe choices and family drama soon spiraled into a full-blown rupture. By 2020, Meghan and Harry had exited the royal firm in what the press dubbed Megxit. They relocated to California, signed multi-million-dollar deals with Netflix and Spotify, and rebranded themselves as media entrepreneurs and global philanthropists. Yet they retained the titles of Duke and Duchess of Sussex, an agreement fraught with unspoken conditions and silent scrutiny. That scrutiny intensified with each passing year. Meghan began referring to her son Archie as Prince Archie in interviews and digital content. In a Netflix documentary titled simply Harry and Meghan, the children were openly named as Prince Archie and Princess Lilibet. This might have seemed harmless branding to some, but within the British constitutional framework, it was a serious breach. Titles, especially royal ones, are not private property. They are granted, revoked, or modified solely by the reigning monarch or Parliament, and only under specific circumstances outlined by royal charters, including the 1917 letters patent issued by King George V. which restricted royal titles to the children and grandchildren of the monarch in the male line. At the time of Archie's birth, Queen Elizabeth II had not extended this privilege to him, nor had King Charles III made any proclamation granting Lilibet a title upon her birth. And yet, on digital platforms and across public documents in the U.S., the titles Prince Archie and Princess Lilibet appeared prominently. Initially, Buckingham Palace remained quiet, perhaps hoping the issue would fizzle out. But behind the walls of power, murmurs were growing louder. When journalists investigated the Sussexes' official website, they discovered language that implied royal privileges far beyond what had been publicly agreed upon. Sponsors and media partners were allegedly advised by the Sussex team to refer to the children by their titles, even in legal drafts. A leaked email from a Sussex PR rep read, "All press must acknowledge their royal status as prince and princess in future documentation." That email lit the match. The Royal Titles Committee, a largely ceremonial group that hadn't met in decades, was suddenly activated by Parliament. And this time, it wasn't a polite gathering. Legal scholars were summoned. Constitutional experts delivered reports. Even former royal aides were brought in to give testimony. Their findings were stark. There was no legal basis for Meghan to assign these titles without explicit approval. Then came the tipping point. A Conservative MP, Lady Alexandra Redford, stood before the House with a speech that made global headlines. This is not about children. This is about monarchy, about order, about the sovereignty of the crown. Titles are not souvenirs from a failed institution. They are sacred, and they must be protected. Her voice, sharp and resolute, resonated through Westminster. Within hours, MPs from all parties joined the cause, either out of loyalty to the institution or in response to the growing public outrage over what was seen as yet another Hollywood hijacking of British tradition. The vote came swiftly. The Royal Title Clarification and Protection Act passed its second reading with little opposition. It declared that no individual residing outside the United Kingdom, who is no longer a working member of the royal family, may apply, use, or distribute titles of royal inheritance on behalf of minors without approval from the sovereign or parliament. Penalties included a formal court summons, potential removal of titles for the parents, and an international investigation into possible fraud in legal documentation. The legislation hit the Sussexes like a thunderclap, but what truly shook the world was Meghan's silence. For days after the bill passed, her team released no statement. Journalists camped outside their Montecito estate. Lawyers in London and Los Angeles scrambled to decode the international implications. What did it mean for a non-resident of the UK to be summoned over a constitutional offense? Could she be compelled to appear? Would it escalate to a full international legal case? Meanwhile, Meghan's defenders rallied. American celebrities tweeted in her support. Civil rights activists accused the UK government of racially motivated overreach. "You didn't care when Andrew was cavorting with Epstein," one commentator wrote. "But you're sending the full power of Parliament after a mother who called her kid Prince?" The backlash was furious, but the momentum in London was unstoppable. In whispered briefings and off-the-record conversations, members of the monarchy hinted at quiet relief. "It's time to restore clarity," one insider said. "People don't understand. If titles can be claimed unilaterally, the entire system unravels. That's not freedom. That's chaos." The court summons was prepared. It would be dispatched via official diplomatic channels, unless Meghan complied with the 14-day demand. Retract all digital references. Strip the names from public databases. Amend all legal documentation. Or face the possibility of appearing in a UK court on charges of impersonation of royal status and fraudulent title use, a charge not seen in modern British history. The stakes, as one legal expert put it, were constitutional, cultural, and deeply personal. The monarchy had survived world wars, divorces, and the death of Diana. But this was a challenge from within, by a woman once welcomed into the fold, now accused of exploiting its symbolism. As the digital clock ticked down on the UK government's official portal, 13 days, 11 hours, 34 minutes remaining, the world waited. Would Meghan comply? Or would she fight? And if she fought, what would the monarchy do next? To understand the intensity and controversy behind Parliament's decision, one must first grasp the slow but deliberate path Meghan Markle took from being a newly minted duchess to becoming, in the eyes of many critics, a self-appointed authority on royal titles. It didn't happen overnight. It was a series of calculated steps, shifting statements, subtle digital changes, and unmistakable public messaging. It was not just about motherhood. It was about power, image, and the reshaping of legacy. When Meghan Markle married Prince Harry in May 2018, she entered the British monarchy as the Duchess of Sussex. By the Queen's designation, the couple held their titles as representatives of the Crown and members of the royal working family. At that point, the lines were clear. Meghan was granted an official title by sovereign approval. She had no independent authority to grant titles to others, not even her children. But the seeds of challenge were already being planted. Back in 2018, during Meghan's first public outings as a royal, she made it clear through interviews and body language that she had little interest in tradition for tradition's sake. Her speeches, wardrobe choices, and interactions with the press marked her as a disruptor. Within royal circles, this wasn't always unwelcome. Some insiders initially viewed her as the refreshing gust of modernity that the family desperately needed. But it didn't take long before enthusiasm turned to caution and then to concern. By the time Archie Harrison Mountbatten Windsor was born in May 2019, that tension was already simmering. Meghan and Harry made the unprecedented decision not to grant their child a title at birth, even though, by the 1917 letters patent issued by King George V, he would have become a prince once his grandfather, Charles, ascended the throne. At the time, the Sussexes cited their desire for Archie to live a normal life, free of royal burdens and media intrusion. The press noted how their decision broke away from the traditional practices of royal naming ceremonies and title declarations. However, what was presented publicly as a selfless parental act would soon become the subject of contradiction. Just months after stepping back from royal duties in 2020, Meghan began hinting that the decision to withhold Archie's title wasn't theirs at all, that it had been denied to him because of who she was. In her explosive interview with Oprah Winfrey, she alleged that conversations had taken place within the palace about whether Archie would be given security, and that they didn't want him to be a prince. This remark triggered a firestorm. Was the monarchy trying to erase Meghan's children from the royal line? Or was this a mischaracterization of royal protocol? The truth, legal experts would point out, was that Archie was simply not entitled to the title at birth under the current rules. Those rules stated that only the children of the monarch, the children of the monarch's sons, and the eldest son of the Prince of Wales's eldest son would be styled as prince or princess. Since Archie was the great-grandchild of Queen Elizabeth II, and not the eldest son of Prince William, he didn't automatically qualify until Charles became king. Nonetheless, Meghan's words were carefully chosen and emotionally resonant. The insinuation was clear. The monarchy was choosing to deny her child a title, and by extension, legitimacy and protection, possibly motivated by race. That implication struck a nerve, not only in the UK, but globally. What began as a matter of protocol quickly became a narrative about bias, exclusion, and historical injustice. This framing stuck with much of the public, especially in America. From that moment onward, Meghan's relationship with royal protocol became increasingly self-directed. The Sussexes launched their own digital media empire, unveiled the Archewell Foundation, and entered into commercial agreements with streaming platforms. Through these channels, the names and perceived statuses of their children began to evolve. On official press releases and website bios, references to Prince Archie and Princess Lilibet appeared gradually, as if the matter had been settled with royal consent, when in fact, no such declaration had ever been formally made public by the king. Following the passing of Queen Elizabeth II in September 2022, Charles became king, and that's when the issue reached its boiling point. With the monarch's ascension, Archie and Lilibet technically became eligible to inherit the prince and princess titles under the 1917 letters patent. But there was a crucial catch. Eligibility is not the same as entitlement. The final decision still rested with the reigning monarch, and traditionally, such confirmations are made through formal announcements from Buckingham Palace. No such announcement came. Instead, what happened next shocked even seasoned royal observers. On March 9, 2023, a statement from a Sussex spokesperson declared, "I can confirm that Princess Lilibet Diana was christened on Friday, March 3rd, by the Archbishop of Los Angeles." The statement caused a seismic jolt, not just because it revealed a private religious ceremony in the United States for a member of the royal family, but because it marked the first public and official use of the title Princess Lilibet. There had been no communication from the palace, no press release from the king, no acknowledgement from Parliament. And yet, here it was, stated as fact by the Sussexes themselves. The wording left little room for ambiguity. It wasn't speculation. It wasn't framed as she may become princess. It was presented as a completed fact. And that was the turning point. The media latched onto the story. Legal analysts took notice. British lawmakers began whispering about jurisdiction, inheritance, diplomatic responsibilities, and misuse of status. The government had largely remained quiet about the Sussexes' growing use of royal branding on their website and children's documentation. But now, with the children referred to as prince and princess in formal announcements and legal language tied to church records, the line had been crossed. What made matters worse was that these declarations came amid ongoing commercial activity from the Sussexes. Their Netflix series portrayed their children as titled royals, complete with royal backdrops, family emblems, and subtle nods to monarchy. Critics accused the couple of using their children's supposed titles to lend weight to their public image, to sell the Sussex brand, and to assert continued relevance in the global aristocratic ecosystem. Meghan's defenders argued the opposite, that she was simply claiming what was rightfully hers and her children's by birth. Still, the facts remained. There had been no formal bestowal of these titles, no palace communication, and no royal proclamation. The absence of these key elements made the Sussexes' actions problematic in the eyes of British constitutionalists. To them, Meghan was not merely asserting a maternal right, she was actively redefining royal heritage through unilateral declarations. In January 2024, the Sussexes updated their official website once more. The About section now read, "Prince Archie and Princess Lilibet, our beloved children, are a testament to a future where compassion and dignity guide leadership." The titles were not accompanied by any footnote, legal caveat, or acknowledgement of pending approval. To viewers around the world, it seemed official. But inside British institutions, alarm bells were ringing. Parliamentarians from both sides of the aisle began consulting with royal legal scholars and former aides to Queen Elizabeth II. Many of them viewed Meghan's actions not just as a breach of tradition, but as a manipulation of constitutional order. Unlike celebrity titles or social labels, royal titles are governed by centuries of legal precedent. In a monarchy that claims to exist by the will of the people and the grace of constitutional law, such titles must come from the crown, not from self-declaration. This wasn't just about nomenclature. It was about sovereignty. If individuals could declare themselves or their children royal, the entire framework of the monarchy would collapse into brand warfare. Parliament, realizing the long-term implications, knew it had to act. There was also the international dimension. American media companies, investors, and publishers were partnering with the Sussexes under the assumption that they carried legitimate royal lineage and influence. By letting the unauthorized titles remain unchallenged, the British establishment risked a slow erosion of its own constitutional credibility. The royal institution is not just symbolic, it's legal. And titles carry privileges, implications, and responsibilities. In certain circumstances, they can influence diplomatic relations, passport classifications, or even property rights and inheritance laws tied to royal estates. This escalating situation compelled Parliament to take unprecedented action. Quiet letters were sent to legal representatives of the Sussexes. One message reportedly read, "The use of royal titles without confirmation or consent may constitute a misrepresentation of sovereign status under UK law." The message was ignored, or, as some speculated, challenged behind closed doors. Meghan's legal team insisted that her children's entitlement was automatic upon Charles becoming king. But Parliament saw things differently. Without formal recognition or proclamation, there was no authority for such use. Thus, the Royal Title Clarification and Protection Act began to take shape. It wasn't about removing the Sussexes' titles, though some MPs strongly favored that option. It was about setting a boundary that hadn't been enforced in centuries. For the first time, the British government would legislate over who could publicly claim royal titles and under what conditions. The legislation directly cited Meghan's public use of the terms Prince Archie and Princess Lilibet in digital platforms, legal documents, and promotional material for Archewell. The bill's language was sharp and deliberate. It stated that any such unauthorized use would be considered a misrepresentation of royal status, and violators would be subject to civil inquiry and potential prosecution for impersonation of state-affiliated identity. To Meghan's supporters, the move seemed punitive, even cruel. Why persecute a mother over what she calls her children? But to defenders of the crown, it was not personal, it was existential. They saw it as a necessary correction to a dangerous precedent. If the monarchy was to survive in a modern democracy, it had to retain control over its symbols, its structure, and yes, its names. The battle lines had been drawn. On one side, Meghan Markle, a woman who had reinvented herself as a global figure of defiance and reform, wielding the weapon of narrative and media control. On the other, a centuries-old institution fighting to preserve the very thing that makes it sacred, its exclusive right to confer honor, identity, and tradition. As the controversy over the Sussex children's titles surged into the headlines, a growing number of legal experts, royal advisors, and members of parliament were no longer asking whether Meghan Markle had overstepped royal boundaries. They were asking if what she had done could, or should, be classified as a legal offense. What began as whispers in the hallways of Westminster had matured into an urgent legal inquiry. Could publicly declaring one's children prince and princess, without authorization from the sovereign or parliamentary consent, constitute fraud? To many legal minds in the United Kingdom, this was uncharted territory. The British legal system, centuries old and grounded in both statute and common law, had rarely confronted such a problem. There were volumes of constitutional guidance on how titles were granted, managed, and revoked. But what about when someone used a title without permission? And not just socially, but commercially, publicly, and in a way that directly benefited a private financial operation like Archewell? The earliest internal assessments took place not in courtrooms, but in conference rooms within Whitehall, where senior advisors to Parliament pored over historical legal codes, royal charters, and legislative precedents. What they discovered startled even the most experienced legal historians. The last time Parliament had formally reviewed or codified the misuse of royal titles was over 150 years ago. Back then, issues of impersonation were mostly tied to individuals falsely claiming royal identity for personal gain. Mostly in marriage schemes or fraudulent letters sent to aristocrats requesting money. This modern case was far more sophisticated, digitally embedded, and legally complicated. The situation was further complicated by Meghan's status. She was, after all, still technically the Duchess of Sussex, a title granted to her by Queen Elizabeth II upon marriage. And her husband, Prince Harry, still held his title by birthright. Neither had been formally stripped of their titles following their exit from royal duties. So at first glance, one might argue that their children were simply being referred to in a way that aligned with the natural succession of lineage, especially after King Charles's accession to the throne. But that argument quickly collapsed under legal scrutiny. What the Royal Titles Clarification and Protection Act sought to define was not biological legitimacy or family heritage, but legal authorization. Under British constitutional law, royal titles are not entitlements passed down like genetic traits. They are legal instruments conferred by the monarch or governed by parliamentary decree. The letters patent issued by King George V in 1917, often cited in modern debates over titles, explicitly states that only the children and male-line grandchildren of the monarch are entitled to be styled as prince or princess. Meghan and Harry's children only became eligible when Charles became king. But eligibility is not the same as conferment. The palace had made no public announcement confirming such titles. No formal royal proclamation had been issued. No public record existed of Charles affirming those styles of address for Archie and Lilibet. In fact, palace aides privately conveyed to Parliament that the Sussexes had made no formal request for the children's titles to be officially recognized following the Queen's death. This silence, legal advisors argued, constituted a break in the chain of conferment. The crux of Parliament's case rested on three key areas: unauthorized title usage, digital misrepresentation, and international confusion regarding sovereign identity. First, unauthorized title usage. The bill cited multiple examples of Meghan's public use of the titles Prince Archie and Princess Lilibet in press releases, charity branding, and personal statements. It included documentation of how the names were listed on the Sussex website, in Netflix subtitles, and in legal filings tied to business contracts. These instances demonstrated that the titles weren't being used as colloquial family nicknames. They were being asserted as official titles in public and commercial domains. Second, digital misrepresentation. This element was perhaps the most cutting edge. Lawyers consulted by Parliament emphasized how public figures using monarchical branding could unintentionally trigger consequences far beyond the UK. When a website presents children as royalty, it could affect foreign diplomatic protocols, charity registration classifications, and even visa processing. Several legal experts from the Foreign, Commonwealth, and Development Office warned that embassies had received inquiries from foreign dignitaries unsure of how to address Archie and Lilibet in formal invitations or state protocols. Should they be styled as prince and princess? Were they in the line of succession? What obligations did governments have in recognizing those claims? These questions, seemingly technical, posed serious challenges to the UK's international credibility. If the country could not define or defend its own system of royal identity, how could it expect global institutions to respect its cultural or diplomatic hierarchies? The third legal argument, arguably the most serious, was royal impersonation and potential fraud. Lawyers for Parliament explored whether Meghan's use of unconfirmed royal titles met the threshold for impersonation under existing UK law. They referenced sections of the Fraud Act 2006, particularly those dealing with false representation made with the intention of personal gain or to cause loss to another. While no direct monetary fraud was alleged, the use of titles to secure influence, bolster personal branding, or enhance commercial leverage could fall into a gray area, especially if those titles were used without sovereign or parliamentary recognition. This was the argument that ultimately convinced many MPs that legislation was not only justified, but necessary. One particularly influential voice was that of Sir Gregory Langham, a senior constitutional barrister and lifelong royalist. In his testimony to the committee drafting the bill, he stated, "When a person assumes a title they have not been granted, and uses that title to promote themselves or secure commercial opportunity, they are not merely bending protocol. They are simulating the sovereign's voice. It is no different from forging a signature on a legal document. The Crown's voice must be singular, deliberate, and protected. Anything else is chaos." This statement was entered into the parliamentary record and became a touchstone quote in debates that followed. The Royal Title Clarification and Protection Act included three major legal provisions. First, it established a clear definition of what constitutes an official royal title, a style or designation directly conferred by the monarch or validated by parliamentary agreement. This excluded any assumed titles, unconfirmed hereditary styling, or self-declared statuses. Second, it required all individuals using royal titles in public, digital, or legal documents to provide evidence of formal conferment. This could be a royal decree, a palace statement, or a letter of affirmation from the sovereign's legal advisors. Third, and most controversially, it introduced a criminal offense for unauthorized use of royal titles, specifically when used in contexts that might mislead the public, distort commercial intent, or imply a level of sovereign recognition that does not exist. Violators would be given a 14-day warning to retract such titles from all digital and legal records. Failure to comply would trigger a UK court summons and an inquiry into potential impersonation of royal status under fraud statutes. Critics of the bill argued it was an overreach. Some described it as an act of royalist vengeance masquerading as legal order. Civil rights organizations in the U.S. condemned the idea of targeting a private citizen for naming her children in a way she saw fit. But supporters countered that Meghan was not just any private citizen. She was a former working royal, married into the crown, and leveraging royal symbols for global recognition. Her actions, in their view, directly undermined the legitimacy of an institution that derived its power not from wealth or politics, but from carefully guarded symbolism. The legal framework also raised practical questions. Could the UK enforce a court summons against a U.S. resident? Would international law recognize a sovereign nation's right to control familial titles across borders? Legal analysts agreed that extradition for such a case was unlikely. However, the summons itself, even if symbolic, would carry immense weight. It would mean Meghan could be declared in contempt of court if she ever returned to the UK and refused to comply. It could bar her from entering the country in any official capacity. It could also fuel debates in U.S. institutions about how to legally classify individuals making royal claims without constitutional backing. Parliament, aware of these limitations, focused less on enforcement and more on deterrence. The bill was not designed to throw Meghan into prison. It was crafted to send a signal, to her and to anyone else, that royal identity was not something to be self-ordained. If titles could be turned into brands, then monarchy itself was in jeopardy. In the days following the bill's passage, legal experts took to airwaves to explain the implications. On BBC Radio 4, a special segment hosted by constitutional historian Dr. Emily Radcliffe posed the central dilemma. This is about control over narrative, control over heritage, and control over the meaning of monarchy in a postmodern world. Who decides what a prince is? Parliament has now answered, not Meghan. The Sussex camp, for their part, pushed back. Their lawyers released a statement arguing that the children were inherently entitled to their titles under the 1917 letters patent, and that no separate proclamation was required. They maintained that King Charles's silence was a form of tacit approval, and that the real issue was not legal clarity, but political resentment. Meghan's team also emphasized her identity as a mother. This is not about branding. This is about respect, said her chief spokesperson. Every child deserves dignity. These are Harry's children. They are royal by blood. This attempt to legislate their identity is deeply inappropriate. But even as the Sussexes built their defense, the 14-day clock was already ticking. The legal grounds were now cemented. Parliament had made its move. The law was passed. The charge was defined. Meghan Markle had 14 days to comply, retract the titles, or face the wrath of a centuries-old institution that had finally decided enough was enough. It was a Wednesday afternoon when the House of Commons descended into one of its most emotionally charged sessions in recent memory. The chamber, usually dominated by questions about economic policy or international relations, had turned its full attention to an issue that seemed lifted from a Shakespearean drama, a duchess, stripped of royal duties, now accused of manipulating royal titles, a parliament, long silent on royal matters, finally finding its voice. The subject at hand was the Royal Title Clarification and Protection Act, a bill that, on the surface, addressed the administrative structure surrounding royal nomenclature. But beneath the legal terminology and procedural language lay something far more explosive, a sweeping indictment of Meghan Markle's conduct and a direct challenge to the way she and Prince Harry had defined their post-royal lives. The debate began at precisely 2:15 p.m. local time, with Speaker of the House Sir Lindsay Hoyle calling the session to order. It was immediately evident that this was not going to be a routine affair. The benches were unusually full. Members from every major party had shown up, some out of duty, others out of outrage, and a few purely for the historic significance of what was unfolding. The gallery above was also packed. Journalists, legal analysts, former palace aides, and curious observers filled the rows. Even international media outlets had dispatched correspondents to witness the moment Parliament took a stand against one of the most controversial figures to have emerged from the British royal family in a generation. The bill was formally introduced by Lady Alexandra Redford, a Conservative MP known for her unwavering support of traditional British institutions. Her opening remarks were met with applause from the Tory side and tension from the Labour benches. "Mr. Speaker," she began, her voice steady, clipped, and confident, "this bill is not about vengeance. It is not about family. It is about clarity, about the sanctity of our constitutional order, about ensuring that the titles that define this nation's monarchy are not reduced to mere vanity labels or commercial slogans." Her tone sharpened as she continued. "We have watched as the titles of Prince and Princess, once symbols of duty and service, have been applied to children who reside outside this realm, who have no public service in this nation, and who have not received any formal confirmation from the Crown or this House." She paused as murmurs rippled through the chamber. "We are not punishing children. We are not attacking a woman for the name she gives her family. We are defending the foundation of constitutional monarchy, and we are protecting the voice of the Crown from being replicated without consent." It was a deliberate, measured speech, and it struck its intended chord. By the time Lady Redford sat down, the mood in the chamber had changed. The issue was no longer framed as a family dispute, but as a matter of institutional integrity. Labour MP Malcolm Forster stood next. A staunch Republican by philosophy, he surprised many by supporting the bill. "While I may not agree with the existence of the monarchy," he said, "I do believe that, so long as it exists, it must be safeguarded from misrepresentation. Let us be clear, this is not a free speech issue. No one is being told what to say in their living room. This is about official documents, public representation, and international diplomacy. If someone wishes to claim a royal identity, they must do so through the correct, legal process." He continued, his voice tinged with frustration, "and let us not ignore the commercial implications here. These titles are being used on television, on books, on streaming platforms, on official websites connected to businesses. What are we teaching the public if we allow royal identity to be claimed without process? That celebrity is enough? That attention overrides the law? The House fell into an uneasy silence after his remarks. The lines between parties were blurring in real time. It wasn't a fight between conservative and labor, or even between royalist and republican. It was a collision between order and improvisation, between process and personality. Opposition to the bill was limited, but vocal. Liberal Democrat MP Harriet Linton voiced concern over the optics and timing. I worry that this legislation, no matter how carefully drafted, will be seen globally as a form of retaliation. We must consider the racial and cultural context in which Meghan Markle has operated. Are we applying the same scrutiny to other royals? To those born into privilege who commit indiscretions far worse than misusing a title? This line of argument struck a nerve, especially among younger MPs and the more progressive elements of the House. For a moment, the chamber buzzed with the tension of identity politics clashing with constitutional law. The notion that Meghan was being held to a different standard, perhaps because of her race, nationality, or celebrity, was not lost on the public, nor on the members in attendance. But the majority of speakers brought the discussion back to the legal issue at hand. Sir Thomas Kent, a respected crossbench MP and constitutional scholar, gave perhaps the most dispassionate and devastating argument in favor of the bill. If we allow individuals to self-declare as royalty, we undermine not only the monarchy, but also the very nature of British law. Titles are not metaphors. They are legal constructs, imbued with authority, inheritance, and responsibility. When they are used falsely, it is not merely an insult, it is a fraud. He turned toward the gallery where journalists and foreign observers Saturday. To our international friends watching, let me say this. The United Kingdom respects free speech. But we also respect formality, structure, and law. You do not get to be royalty because you wish it. You become royalty because this institution, centuries in the making, recognizes you as such. At one point, the House erupted into heated crosstalk when a backbench MP made an offhand comment comparing Meghan's behavior to a celebrity licensing deal. Shouts of order, order, rang out as Speaker Hoyle banged his gavel, demanding decorum. Yet amid the political fireworks, a curious and telling absence hovered over the entire session, the palace. Not once during the day-long debate did any official spokesperson from Buckingham Palace release a statement. There were no comments from King Charles, no subtle leaks from Prince William's team, no counter-message from Queen Camilla. The palace, it seemed, had made a choice to let Parliament act as the voice of accountability while remaining above the fray. Their silence was widely interpreted as consent, or at least as unwillingness to interfere with what many insiders believe they secretly supported. Multiple MPs referenced that silence during the debate. If the king believed this was an overreach, MP Sandra Keating noted, he could have stepped forward. He is not, and that should tell you something. The turning point in the session came just after 5:30 p.m., when the results of the preliminary procedural vote were called. By a margin of 378 to 58, the bill passed its second reading. The chamber roared, not in triumph, but in sheer release of tension. After months of speculation, political hedging, and media frenzy, Parliament had chosen a side. Outside, reporters mobbed MPs as they exited the chamber. Some were cheered. Others were booed. Protesters supporting Meghan had gathered along Parliament Square, holding signs that read, "Stop the witch hunt," and titles are her children's right. Meanwhile, royal traditionalists chanted slogans about heritage and legality, waving Union Jacks and photos of Queen Elizabeth II. Back inside, the bill was scheduled for final adjustments before a full vote. But the tone had already been set. The message was clear. This was not a petty spat. This was Parliament, the lawmaking heart of the United Kingdom, declaring that even former royals living abroad could not distort the rules that define the realm. Perhaps the most chilling takeaway came from an unlikely source. MP Douglas Hale, a centrist who rarely spoke in emotional terms, delivered a closing thought that sent shivers through the gallery. This institution survived Henry VIII. It survived the abdication crisis. It survived Diana. It will survive Meghan Markle. But we must act now, because if we allow titles to become content, the crown becomes just another influencer. and Britain loses something sacred. By the time the House adjourned, the vote had sent shockwaves across the world. Meghan's team, still silent, had been given a clear warning. Parliament was no longer content to watch. The lines were drawn, the law was advancing, and the countdown had begun. In the immediate aftermath of Parliament's overwhelming support for the Royal Title Clarification and Protection Act, the most deafening reaction came from those who said nothing. No official statement, no emergency address, no hasty rebuttal. Just an eerie, calculated silence that rolled out from the gates of Buckingham Palace and blanketed the airwaves like fog on a cold London morning. For days, the British public waited for the palace to speak. After all, the bill, although legislated by Parliament, was essentially about the monarchy. It questioned who had the authority to define royalty, to declare a child a prince or princess, and to preserve the mystique of the crown itself. If anyone should have offered a guiding hand or official sentiment, surely it would be the monarch. But King Charles III, known for his caution and love of control behind the scenes, offered no such hand. Not directly. Instead, what emerged was a whisper campaign of silence. A carefully curated message not spoken in front of cameras but delivered through body language, courtier gossip, and the quiet removal of any trace of ambiguity. The firm, an internal term used to describe the royal institution as a whole, had clearly chosen a strategy. Stand back, let Parliament take the lead, and speak only through subtle shifts in protocol. Inside royal circles, that silence was not confusion. It was fury, contained and repressed beneath layers of royal protocol. Behind closed doors, it became apparent that Meghan's unapproved declarations of royal status for her children had become a sore point not just for Charles, but for the entire royal household. Some saw it as an insult to the Queen's legacy. Others viewed it as a dangerous precedent that, if left unchecked, would threaten the order and structure that the monarchy depended on for survival. King Charles, by nature, is a monarch of soft power. He rarely speaks with force unless it's on matters of climate, architecture, or religion. But those close to him understood the subtext of his silence in this matter. In one leaked email between royal aides, a senior advisor allegedly remarked, "His Majesty will not be baited into a war of words with his own son's wife, but he also will not validate titles that haven't been formally recognized. The law will speak for us." This was more than emotional restraint. It was a coordinated decision rooted in constitutional positioning. The palace was well aware of the optics. Were Charles or William to publicly denounce Meghan's actions, it would immediately be framed by global media as a continuation of the family feud, adding fuel to the fire already lit by the Oprah interview, the Netflix series, and Harry's memoir, Spare. The palace understood it could not win that war of narratives. So it chose a different battlefield, quiet legitimacy. In royal residences, Meghan's public use of the titles Prince Archie and Princess Lilibet had been discussed long before Parliament took action. Courtiers had grown uneasy each time a press release from the Sussex camp used the titles without having sought any clarification from the palace. These were not oversights, they were calculated maneuvers, and the firm knew it. As the legal gears of Parliament began to grind and the silence from Buckingham Palace solidified its position, the world turned to one woman, Meghan Markle. All eyes focused on her Montecito estate in California, where she now stood at the center of a constitutional confrontation that had traveled across oceans and centuries. While Parliament had voted, the palace had withheld its voice, and the media had gone into overdrive. Meghan had remained notably absent from the public eye. No tweets, no interviews, no surprise appearance at a charity gala. Just silence. For a woman who once defined her public life through strategic visibility, her absence was both curious and deafening. Then, just as speculation reached a boiling point, she reemerged. Not with an apology or retraction, but with a declaration that felt more like a warning shot than a public statement. In a carefully staged video released through Archewell's official YouTube channel and social platforms, Meghan sat in front of a sunlit window, dressed in understated but elegant ivory, flanked by framed family photos. Her tone was calm, but the message beneath the words was unmistakably firm. "My children," she began, "are born of royal blood. Their titles are not props, nor are they favors that can be granted and withdrawn like applause. They are part of a lineage, a history, a truth, and I will not allow anyone, not a government, not an institution, not even centuries of tradition, to tell me who my children are allowed to be." The statement echoed like a thunderclap across both sides of the Atlantic. Her words were deliberate, intentional, and loaded with subtext. On one hand, she was defending the rights of her children. But on another level, she was drawing a line in the sand, asserting that she, not Parliament, not Charles, not the firm, would be the one to determine the identity, legacy, and presentation of Archie and Lilibet. Meghan's defiance was not without precedent. She had built her public persona on challenging systems, from Hollywood's treatment of women of color to the British tabloid press to, now, the monarchy itself. What shocked many wasn't that she resisted. It was how unapologetically she did it, even when facing potential legal consequences from a foreign government. In the same video, she laid out her case with rhetorical precision. When my husband and I stepped back from royal duties, we didn't step away from our family. We didn't renounce heritage. We chose freedom. And with that freedom comes the right to speak the truth and to protect our children. She then went further. When King Charles ascended to the throne, our children became eligible for their titles under long-standing tradition. We honored that moment not by seeking a crown, but by naming them as who they are: Prince Archie and Princess Lilibet. We do not need permission to speak the truth. That phrase, "we do not need permission to speak the truth," was picked apart by legal experts, commentators, and royal watchers alike. It was a bold assertion, suggesting that Meghan believed the legitimacy of the titles was not based on legal conferment, but on lineage and moral clarity. She positioned herself as a mother refusing to let history erase her children. The British press reacted furiously. The Daily Mail ran with a headline declaring, "Markle declares war on Britain's constitution." The Telegraph framed her words as an unconstitutional rebellion cloaked in maternal defiance. On BBC Newsnight, a panel of former MPs and royal historians debated whether her statements had crossed into sedition. A growing consensus emerged among constitutional scholars that Meghan's message was not just public relations, it was a political act. In the United States, however, reactions were mixed. Some saw her as a woman standing up for her children against an archaic and out-of-touch monarchy. Major outlets like the New York Times and MSNBC framed the story as a cultural clash between a modern woman asserting her autonomy and a royal family clinging to 19th-century rules. Social media erupted with hashtags like #PrincessLilibet and #StandWithMeghan trending globally within hours. Celebrities chimed in, most of them rallying behind her. Oprah Winfrey reposted the video with a single line: "Every mother has the right to protect her child." But Meghan's defiance wasn't limited to speeches and videos. Behind the scenes, she had mobilized her legal team, activating attorneys from both her U.S. counsel and international legal advisors in London. According to sources close to the situation, her lawyers prepared a comprehensive legal memorandum arguing that Parliament had no jurisdiction over her naming decisions, particularly as she and her children were not residents of the United Kingdom. The memo cited the 1917 letters patent and argued that since Archie and Lilibet met the criteria laid out under King George V's declaration, being the grandchildren of the reigning monarch in the male line, they were entitled to their titles by default, and no further action was necessary. Furthermore, Meghan's legal team prepared to challenge the law's application to international digital domains. One lawyer, speaking anonymously to Reuters, claimed the UK cannot enforce regulations over American websites or press releases issued in California. The concept of jurisdiction simply does not apply in this context. You can't police language in another sovereign country. This legal theory, while complicated, found support among some international law scholars. However, it failed to address one critical aspect of the new law: the potential consequences should Meghan or Harry step foot on British soil. According to the statute, if Meghan failed to comply with the 14-day removal order, she could be summoned to appear before a UK court on charges of impersonating or misrepresenting royal status. If she refused that summons, she could be declared in contempt, potentially risking her ability to return to the UK for any future reason, including family matters or even coronation events. Despite the implications, Meghan appeared undeterred. Her team did not remove or edit the Sussex website. The references to Prince Archie and Princess Lilibet remain visible on bios, charity descriptions, and legal documents filed for the Archewell Foundation. More notably, newly released promotional materials for a children's book she was co-authoring included a dedication to Prince Archie and Princess Lilibet, who remind me daily that love makes royalty real. This move was interpreted as a deliberate provocation, a literary and commercial reinforcement of her refusal to comply. Meanwhile, insiders close to Prince Harry described him as being caught in a painful limbo. While Meghan stood her ground, Harry reportedly oscillated between emotional fatigue and fierce loyalty. Those closest to him claimed he supported Meghan publicly but felt deeply conflicted privately. He had once told friends that he never wanted to be the center of a legal war with his country of birth. And now, his children's names were pulling him into exactly that. It didn't help that communication between Harry and his brother, Prince William, had reportedly deteriorated even further. Following the passing of the bill, William made no effort to reach out, nor did Harry initiate contact. The silence between them became emblematic of the deeper family fracture, the royals no longer speaking through emotion or tradition, but through legal documents and institutional silence. Inside the Montecito estate, however, Meghan remained poised. She granted a rare interview to a U.S. magazine where she expanded on her views without addressing the legal battle directly. "I'm not trying to reinvent the monarchy," she said. "I'm simply protecting my family from being erased." She hinted at years of whispered agendas, unspoken power plays, and gatekeepers of legacy who want to dictate who counts. In that interview, she also addressed the phrase title fraud that had been used in British media. "What's fraudulent," she said, "is pretending that tradition means justice. What's fraudulent is suggesting that my children don't belong to the same family line because they were born in America or because their mother has the audacity to speak." But not everyone bought the narrative of noble defiance. Critics pointed out that while Meghan claimed to reject royal systems, she continued to benefit from the very institution she challenged. Her foundation, book sales, public speaking gigs, and social media reach all drew heavily from the royal mystique. As one royal biographer wrote in The Spectator, "You cannot reject the throne and still sit on its symbolism." Still, the court of public opinion remained divided. To some, she was brave. To others, manipulative. But no one could deny her resolve. As the 14-day deadline approached, there was no indication Meghan would yield. Her legal team doubled down, preparing a statement to challenge any summons. Her digital team ensured all press bios, charity statements, and published works used the titles as consistently as before. Her defenders remained vocal, while her critics only grew louder. Yet she stood at the center, calm, unwavering, and unafraid. Meghan Markle had made her choice. She would not retract the titles. She would not apologize. She would not obey. As the deadline imposed by Parliament loomed, the battleground shifted from public statements and legal theory to something far more technical, intricate, and unrelenting: the digital realm. At the core of the Royal Title Clarification and Protection Act's enforcement mechanism was a mandate requiring Meghan Markle to remove all unauthorized references to Prince Archie and Princess Lilibet from every digital platform under her control. To some, it might have seemed like a simple request. But within hours, it became evident that this was not just a matter of deleting a few words from a website. It was a complex war for control over narrative, identity, and legacy, fought one line of code at a time. From the moment the 14-day ultimatum was announced, the internet became the focal point of intense global scrutiny. Legal experts, digital analysts, and curious observers flooded Meghan and Harry's online presence with microscopic attention. The Sussexes' official website, archwell.com, was the first target. Almost immediately, screenshots of their About section, biographies, and charitable initiatives were being circulated on social media, with red circles highlighting every use of the words prince and princess. The site listed both children as Prince Archie Harrison of Sussex and Princess Lilibet Diana of Sussex, included under the tagline "Members of the Royal Family Dedicated to a Global Mission of Compassion." The titles weren't just passive references. They were embedded in metadata. HTML headers, image tags, internal URL slugs, and even search engine optimization descriptions. Digital forensic teams consulted by British media explained how these tags play a massive role in search visibility, brand identity, and content indexing. In short, the Sussexes' digital footprint was deliberately constructed to ensure that whenever someone searched Prince Archie or Princess Lilibet, Archwell would appear at the top. That was not an accident. It was digital strategy. And under the new law, it was now a liability. What made the situation even more volatile was the breadth of Meghan and Harry's digital reach. Their presence extended far beyond their website. References to their children's royal titles were embedded in Netflix documentary transcripts, Spotify podcast metadata, book publisher websites, guest speaker bios. and syndicated magazine interviews published across dozens of news and entertainment platforms. Some content, such as articles and videos published by major media outlets, were protected under editorial independence and could not be legally altered. But content directly owned or curated by the Sussexes fell squarely under the law's jurisdiction. The challenge for Meghan's team became immediately clear. If they were to comply with the law, they would need to erase or edit every public digital instance where Prince or Princess had been used to describe Archie and Lilibet. Not just the front-facing content, but also the underlying metadata, SEO tags, embedded video transcripts, linked database entries, and all cached content across search engines like Google, Bing, and Yahoo. It was a massive undertaking, and it wasn't clear whether Meghan had any intention of doing it. When the law was passed, Parliament didn't issue a team of digital auditors to monitor compliance. Instead, they relied on open-source reporting, public complaints, and watchdog organizations to keep track of infractions. Within 48 hours, private digital watchdogs like Crown Cyber and Monarchy Monitor had already compiled detailed PDF dossiers listing over 200 instances of unlawful title usage across platforms linked to Meghan and Harry. One such report listed Prince Archie referenced in the HTML title tag of Archewell.com's charity page. Princess Lilibet appearing in the YouTube caption of a speech by Meghan at a women's conference. Use of HRH Prince Archie in the metadata of a press release archived on PR Newswire. Amazon listings for Meghan's children's book with the subtitle, Written for My Son, Prince Archie. Newsletter sign-ups on Archewell branded with a message from Prince Archie and Princess Lilibet. Digital marketers explained how scrubbing such references would require a total overhaul of Archewell's web structure. It would involve hiring a digital forensics team, revising all templates, manually replacing image captions, and initiating cache removal requests with third-party platforms like Google. Even then, it could take weeks or months for the changes to fully propagate across global search engines. The question was, did Meghan intend to do any of this? All signs pointed to no. The Archewell website remained untouched. All titles remained active. Press releases, newsletters, and even the website's donation receipts still bore the full styling of Prince Archie and Princess Lilibet. This refusal raised the stakes considerably. Parliament had made the law clear. Failure to remove unauthorized titles within 14 days would result in a formal court summons under the newly outlined offense of royal impersonation. Meghan's digital defiance was being read as more than neglect. It was now being interpreted as an outright challenge to the Crown's authority in cyberspace. Meanwhile, the palace refused to intervene. Their digital team, while well-resourced, maintained a long-standing policy of minimal public interference with external websites. They would not send takedown notices or issue statements about the Sussex domain. This absence of action created a void that Parliament attempted to fill through legislative pressure. Interestingly, one of the most important developments came not from the UK, but from the US Department of Justice. Though they made no official statement about the case, internal discussions reportedly began over whether the Sussexes' use of British royal titles in American legal filings, especially those related to Archewell's charitable registration and tax documentation, could violate any transparency statutes in the US. These concerns, while speculative, caused unease among some of Meghan's advisors. If British legal pressure triggered transatlantic scrutiny, the consequences could snowball beyond the symbolic. Adding further complexity was the presence of cached and archived content. Even if Meghan agreed to comply and began removing all visible references, the Internet's memory is not so easily erased. Archive.org and similar platforms had stored every version of Archewell's website since its launch. Anyone could visit those older versions and verify that the titles had been used, repeatedly and strategically. This left open the possibility that Parliament, even if denied real-time enforcement, could still present overwhelming evidence of past violations to justify further legal steps. It became a race, not of time, but of interpretation. Would the Sussexes be judged for failing to comply with the removal of the titles? Or would they argue that their usage fell under the protection of free speech, digital sovereignty, and lineage entitlement? At the core of this battle was a deeper question that no law had yet resolved. Who owns a royal identity in the digital age? Unlike previous centuries where titles were carried on paper, spoken in courts, and etched onto plaques, the 21st century had ushered in a far more fluid and borderless environment. Anyone with a keyboard could claim any identity and project it to millions of people instantly. The British monarchy, rooted in symbols and structure, now faced its most elusive enemy, not rebellion, but rebranding. Even Google became involved, albeit inadvertently. Algorithms designed to prioritize search terms based on keyword popularity continued to suggest Prince Archie and Princess Lilibet in autocomplete boxes. This wasn't an act of recognition, it was the result of how frequently those terms had been searched, indexed, and echoed across the internet. Meghan's defenders argued this as proof of public will. Her critics saw it as manipulation of a platform that didn't understand the legal boundaries it was unwittingly crossing. In Parliament, MPs tasked with monitoring the law's enforcement began submitting digital audit reports weekly. Some suggested hiring a third-party compliance agency to review all Archewell-related content. Others proposed levying symbolic fines or sanctions against companies that published the unauthorized titles. None of these proposals were legally binding, but they signaled a growing appetite for tangible action. Still, there were limits. The UK government had no legal authority to shut down American servers, fine US-based publishers, or demand edits to California-registered websites. What it could do, however, was apply pressure where it mattered: visa status, travel arrangements, public trust, and future honors. Any contempt ruling could, theoretically, become a stain on Meghan's legal record in the UK, affecting her ability to attend royal functions or even set foot on British soil without risking formal proceedings. The public watched closely as the deadline approached. Cyber watchdogs issued hourly updates on changes, or lack thereof, on Archewell's site. Hashtags like #DigitalDuchess and Royal Scrub trended alongside Free Lilibet and My Prince Archie. The internet, like the issue itself, had become a battlefield of truths, half-truths, and curated realities. When the 14th day arrived, no changes had been made. Every unauthorized use of prince and princess remained visible. The digital evidence was intact. Parliament had its proof. Now the question shifted to what would come next. Would the summons be delivered? Would courts be convened over a royal identity declared on a website? Would the crown remain silent or finally intervene? In the modern world, history is no longer written in ink. It's typed, indexed, stored in cloud servers, and searched by billions. Meghan Markle had made her stand not just through speech or law, but through the enduring language of the internet. And in doing so, she may have rewritten more than a title. She may have redefined what monarchy means in the age of digital permanence.